Hello. So our update today is about detention and immigration bail. As you all know, if you are here and subject to immigration control, it means that you could be detained if there are lawful reasons for your detention. And also, if your lawful residence is revoked, you could be detained. Our topic today is to look at what detention is, what is lawful detention, and how you can come out of detention. So detention is an administrative power by the Secretary of State through the Immigration Enforcement Services to restrict the liberty of a person in a designated place, either the police station, a prison, or a migration holding center. There must be a reason for detention. You cannot detain somebody who is here lawfully, unless, of course, their leave to remain has been revoked. The other part is that if somebody has got a right of abode, the person cannot be detained. If somebody is exempt from immigration, the person cannot be detained. In addition, there are other exceptions to detention. Although a person may be liable to detention, if the person falls within the adult at risk or other people who are exempt because of particular circumstance of their case, then they cannot be detained. A pregnant woman should not be detained. However, if they are detained, then they have to be detained for only 72 hours unless special reasons have been given. There is only one reason for detention, and it's to remove the person. The Secretary of State, or for that matter, the immigration officer or the enforcement officer, cannot detain you because they want to punish you. Detention is not imprisonment. It cannot be used to punish someone who has breached the immigration rules. It is therefore important that when your detention has been sanctioned, you must ask to see what the reasons are. Again, if you're not going to be removed within 72 hours, then you could challenge the detention in court or through the chief immigration officer. Just remember that if you're detained for less than 9 days, you cannot make an application to court. Your application for bail or for release or temporary admission, which is now also called bail, can only be through the Secretary of State and the immigration officer, the chief immigration officer. Immigration detention is usually under Schedule 2 of the 71 Act. The bail requirements have been changed since 2018, and therefore it is the Secretary of State through the immigration services that determines the conditions of bail, including reporting to an immigration officer, even if you've been granted immigration bail. So for you to understand the need for immigration detention, you must be told for the reasons why. You must be told the reasons why you're being detained. The immigration officer, who may have a power of arrest, either an administrative power of arrest or a criminal power of arrest, if they have you at a police station, they must follow the terms of the conditions that you can be detained. If you're detained administratively, you're not subject to the PACE requirement, which is the 1984 Act, which has been amended. If you're detained for a criminal offense and it's not an administrative arrest or detention, then of course you are subject to review the first 6 hours, the 9 hours, and then 24 hours. As I've said, you can ask for bail. A bail will normally have to show that you've got accommodation. If you don't have accommodation and don't know anybody in the UK, then you can ask for a bail accommodation. Alternatively, you can contact BID, which is Bail for Immigration Detainees, and that organization will provide you or look for accommodation for you. You may also need to provide people who will stand as sureties for you. Although the name has been changed, the concept is the same. The recognizance, which is the amount that you have to show, is also the same. And you have to show that when you're granted bail, you will comply with your bail requirements and that your removal is not imminent. If your removal is not imminent, the law says that you should be given bail. Unless, of course, you have previously absconded. Even that itself is not a reason to continue with detention. Removal must be imminent. Thank you very much.